Good morning. Good morning. So we started last week by talking about the next to the last commandment. Although, as I mentioned last week, we will talk at the end of this about some of the different ways in which the commandments are ordered, numbered, by different groups. We started talking about the commandment that bearing false witness. And so I started off by actually asking you guys a couple of questions. And since I'm now done with school, I don't get to do this to my students anymore, I'm going to do it to you and check and see if you were paying attention last week. So I asked you a question: what is the difference between proof and evidence? Does anybody remember what I told you was the difference, or what proof was and what evidence was?
Proof is essentially an eyewitness account. Evidence is the examination of things leading up to the suspicion of truth.
Actually, you're thinking of direct and circumstantial evidence, which I appreciate because at least you're paying attention to some of it.
So, I just remember my dog. By the way, I have proof that she eats. She eats my flowers. I have proof. I witnessed it.
You witnessed it. Okay, what that is direct evidence.
Okay.
You witnessed her do it, so you have direct evidence that she did it. And by now, one would hope that would be sufficient to rise to the level of proof for you, having seen her actually do it. Now, as I said last week, one of the problems with proof, and we'll get to why it is in a second, is that because proof is dependent on the perspective of the person to whom you are trying to prove something, if someone has a position that will not allow them to accept a particular premise, you cannot prove to them that premise no matter what you present as evidence. And so if someone is determined that a particular person is innocent, or that what a particular person did cannot be wrong, then there's no way you can prove to them that the person is guilty, because they will not accept any level of evidence no matter how good it is.
Another way to say that is it's impossible to have a rational conversation with an irrational individual.
That's true, but slightly...
I can answer that.
Okay, so yeah, sure. More than most of us, I suspect. Yeah. So first of all, the second question I asked was direct and circumstantial evidence. And Steve has explained that to us, albeit with the wrong words associated with it. Direct evidence is something that supports the truth of an assertion directly without the need for an inference. In other words, Steve saw his dog eating the flowers from the flower bed. That is a direct evidence that he doesn't have to make any inference. He can see that that's what happened. Circumstantial evidence is evidence which supports an inference or a conclusion that the assertion is true. So, fingerprint evidence at the scene of a crime, blood evidence at the scene of a crime, gunshot residue on the hands of someone who is charged with or who is believed to have just shot someone. All of these things support an inference that what the person did was the crime, but nobody can directly say, I watched him do it, okay? So most of the evidence that's presented in most criminal trials is actually circumstantial evidence. And that's okay. That's actually very normal for most criminal trials, and in many cases for civil trials as well. That's perfectly okay. The issue is that there must be evidence. There must be sufficient evidence to overcome the standard of guilt, which in the case of a criminal case, let's see if you guys can remember this, what is the standard of guilt in a criminal case in America?
Reasonable doubt.
Beyond a reasonable doubt. Okay, no, you're thinking of a different thing. That's this the burden of proof.
Okay.
Well, actually, anyway. So now let's try it again though. So we've got direct and circumstantial evidence. Now somebody tell me the difference between evidence and proof.
Before we leave this,
Yeah.
seeing that in black and white right there on the board and everything, it reminds me a lot about some of the theological arguments we get into over one of the proofs that we like to claim, which is necessary inference.
Ah, yes.
Okay, that in a theological sense creates as much havoc at times as circumstantial evidence does in a legal sense, I would imagine.
That's true, although the difference ultimately is that the concept of necessary inference is one that is rife with inherent contradiction, because the notion of a necessary inference is basically the idea that it is unavoidable from what is being said here that you must reach this conclusion. And in law, we never make that argument that you must. What we make the argument is that the evidence overwhelmingly supports that conclusion. And so there can be lots of circumstantial evidence, and taking it together, it can then strongly suggest that this happened. But no, if you're a prosecutor and you got up and argued that the jury must reach a conclusion, you would very likely end up with a mistrial because of that. Because you can't say something like that. You can't tell them that there's no other possible way of understanding it. You can basically tell them, you can show them that there's no other reasonable way to understand it. But it's always dangerous to do that. So there are some overlaps there. And one of the things that circumstantial evidence in a criminal case should do is it should ultimately direct you towards a singular conclusion. If the evidence in a criminal case is directing you towards multiple conclusions that are incompatible, then you have a problem. And generally speaking, that either means the case is going to go away, or it means the prosecutor is going to try really hard to cover up evidence, which is another way to get yourself disbarred. So, in any event, okay. So let's switch over this. Let's try it again. What is the difference between evidence and proof? And we talked a little bit about it here, so hopefully that's giving you kind of a clue to remember what we talked about last week. I'm going backwards here, so this is not the question. The question is actually, let's do this. I'll go past. There we go. Okay. Whoops. There we go. Okay. All right. So now I've kind of, depending on how fast you can read, maybe you actually know the answer now. What is the difference between evidence and proof from a legal standpoint?
Is then the proof that I have the fact to prove it, what I'm saying.
So let's say that's true. Let's say that you have the fact. I don't know how you would have the fact, but let's say the example that you used before where you saw somebody bringing illegal, was it weapons, I think? Illegal weapons into their house, okay? So I am the best friend of the guy who lives there. I can't imagine, under any circumstances, that guy would ever do something criminal. Certainly not something criminal to that level. And I am not particularly fond of you. So if you come to me and you tell me I saw him do that, is that going to convince me that he's a criminal?
No.
No. So you haven't proved to me that he did it.
But if I made a photograph from it, you know, if
I'm going to tell you it's a deep fake, because anybody can fake a photograph. I mean, you can fake whole videos today, so you don't like the guy, I don't believe you.
Feed it then.
Yeah, so here, this is important to understand. We think of proof in terms of, I've satisfied my level of certainty that this is true. But proof is not dependent on what you think unless you're the one making the decision. Proof is dependent on whoever the trier of fact is. So this is the difference. Evidence is anything presented in support of an assertion made in the course of a legal proceeding. Or if we step outside of the court proceeding, evidence is anything that supports an assertion that you're making in general. That your dog is, eating out of the flower bed. That, whatever it might be. Even if it's not necessarily a criminal act, evidence is something that helps to show the truth that something did happen. But proof is enough evidence, this is the types of evidence thing, we don't worry about that. So proof is the presentation of evidence that is sufficient to meet or exceed the applicable standard of proof required for a favorable judgment. That's a big set of terms to basically say you have to present enough evidence so that the trier of fact is convinced beyond whatever the proof is that this actually happened. So in a criminal case, beyond a reasonable doubt. In both civil cases, preponderance of the evidence, a little bit more evidence in favor of your position than the other position. In certain specific kinds of criminal proceedings, not criminal, an actual trial, but certain kinds of criminal proceedings, it would be clear and convincing evidence, which is somewhere between the two of them, and lawyers and judges have been trying to define that one accurately for pretty much all of modern America's time anyway. But, so the issue then is, if you're trying a case in front of a jury, you have, if it's a lesser misdemeanor kind of offense, you have 8 or 9 people. If it's a serious felony, you have 12 people. You need to show enough evidence to all of them to convince them that, in fact, what you say happened is the version of events that actually happened. That's when you've proved it to them, assuming that they say that that's enough evidence to show beyond a reasonable doubt that it happened. Now, that could be enough, just Sylvia saying, hey, I saw them doing it. more likely there's going to need to be some other stuff. So Sylvia said, I saw them taking weapons in. They go in there and they find, powder, or they find residue that's consistent with explosives or consistent with weapons. They find, gunpowder, or they find, rounds of ammunition, things like that are consistent. Those things can work together then to strengthen what she said, and maybe that's it. Maybe that's all you need. Steve?
So proof is somewhat subjective
It's
depending on the person.
completely subjective.
And so it's like necessary inference. It can be subjective as well.
Yes, that's exactly right. Now, in theory, in our brotherhood, the original concept of necessary inference is that it couldn't be subjective. It had necessarily followed. But as applied in practice, and because we're all humans, the truth is that it really is subjective in almost every situation in which necessary inference is applied. And proof is the same kind of a thing. And this is really a hard thing for us to get our head around, because as I said last week, we're used to the idea of our justice system working properly, and it seems sort of squirrely that our justice system should be based on the idea that 12 different people come with a different answer than another 12 different people based on their biases and assumptions and stuff like that. But when you look at some of the most famous cases in history, the one that particularly leaps out because it's even today as it was 30 years ago, it was kind of one of those ones where people couldn't understand how the result was the O.J. Simpson case. And in the Simpson case, you had a whole lot of people who were seeing only part of the evidence, that was all of us, who had come to the conclusion that he had definitely committed the crime. But the 12 people on that jury, not only it wasn't just that some of them thought he didn't do it, all 12 of them ultimately determined that he was not guilty. Or at least, now, that doesn't mean he wasn't guilty. What that means is that there wasn't enough evidence presented to them, or that the evidence that was presented to them was not sufficient to overcome the standard of proof. Now, why that was may be because of racial bias, it may be because of socioeconomic bias, it may be because they saw things that we never got to see. We don't really know for sure what the reasoning was, because while a few of them did submit to interviews, none of those interviews were really targeted at understanding why they made the decision they did in this context, because here's the funny thing, our media has absolutely no understanding of these concepts. I know that's shocking to you, but they don't. If you asked a reporter to explain the difference between these two things, they would have said the things that you said, only they would have said it dumber than any of you said it, because they don't understand these things. Most Americans don't understand these things. So it's really important to realize that proof is a subjective thing based on the perspective of the person who's listening. And there again, that's why it gets us to this idea that you can have the same set of facts, and two people can see the exact same facts. And if one of them really likes the guy and is convinced that he's always right, and the other one doesn't like the guy and is convinced that he's always wrong, the standard of proof that they're going to have is going to be radically different, even if they say it's the same on paper, because of their perspectives. Jerry?
I'm getting a problem with what comes down to truth. And that, whether that is proof or evidence, it's still, it's maybe not in the world we live in that truth is flexible, but at least when we apply this to God's requirement, truth is there somewhere.
Okay, you're absolutely right. But truth is neither proof nor evidence.
No.
And we'll get to that in a second, or Barbara may have a thought on this.
Well, it makes me think of that movie, The Case for Christ, with the reporter. This is an actual true story, where the reporter, his wife becomes a Christian, and he sets out to prove that it's all false. And so, it's interesting all of the things he does to try and prove that something that happened, over 2,000 years ago is not true, and what he comes up with. And, when he gets, does all this research, what his, things he comes up with and finds that are true things that, he can't deal with.
And I think it's important, so when I say that there are there are some people you can't convince of something. That is true. That's a relatively small percentage of the population. What you have, as we have with most things, is you have a lot of people that are towards the middle of the spectrum, and then going further and further out, you have people that are more and more marginalized and more extreme in what they believe. And the further out, or a bell curve is another way of looking at it. And either way, what happens is at a certain point on a specific issue, you reach a point where there are people on the very outer edges who will not change their minds no matter what happens. What you get before you get there are people who it takes an increasingly high level of something being shown to them, of having to see what's really true or what the case really is before they will finally accept what's in front of them. And so most people are not completely sucked into one thing. Now, there are exceptions. Like I said, people who are in cults, for example, a lot of times have pretty much turned off the part of their brain that will question the rationality of what their cult leader does. And there's almost nothing you can do to convince them that they're wrong. You think about, you've had cult leaders who have gotten massive amounts of people to kill themselves. And even as some people are dropping dead, other ones are still drinking the Kool-Aid. Because to them, it doesn't matter what the person says or does or anything else. They have staked themselves to that to the point where they can't make a rational distinction. So there are people on the outer edges, but most of us fall somewhere on a spectrum when it comes to any particular issue. And ideally, when you're trying to create a jury as a prosecutor, you're not so much looking for people who are going to be completely on your side. Because if the Supreme Court finds people that are completely on your side, they usually get worried about whether that was a legitimate conviction. You're actually looking for people in the middle. If you're a defense attorney, you're looking for people on one end of the spectrum that's in favor of your client. So that's kind of what you're going for. But ultimately, different kinds of cases may look for different kinds of jurors. Different facts may yield different kinds of what we're looking for in terms of somebody who's trying the facts. But this gets us to the point that Jerry's making, which is the problem of truth. Okay? So truth is something that is, if we think about it in spiritual terms, or we think about it in Plato's terms, and actually Paul and Plato use a lot of the same language, and I'm not sure who was first, but in any event, the concept that Plato uses of truth is the idea of, the example that he gives us, if you imagine that you were in a cave, and you're sitting with your back to the exit of the cave, up against a rock, and on the wall in front of you of the cave, you can see a fire, the light from a fire that's taking place outside the cave. And passed in front of that fire are various things, people or objects or whatever. And so you can see them on the wall, but it's through the light of a flame, which is kind of, ephemeral, and it's a shadow is what you're really seeing. And so you would be asked, okay, the thing that just went past here is a chair. Tell me what a chair looks like. And you would have to try to describe what does that look like based on what I saw. Well, Plato uses that in the concept not just of like physical things, but of moral and I guess philosophical truths of what is love. It's something that we have an idea about, but we don't fully understand. And Paul talks about this too when he talks about in Corinthians. He talks about now we see as a shadow dimly, then we're going to know what things are. And he's not talking about everything in that context. He's talking about some of the things about God and about the nature of eternity and those kinds of things. But this idea of what is truth, Pilate asked Jesus that question, and Jesus' response is what?
I am truth.
I am truth, exactly. Pilate says, what is truth? And Jesus says, I'm truth. So actually, it goes in the other way around. Actually, Jesus is the one who says, I'm truth, and he asks, what is truth? But the question of what is truth is something that has long plagued us when it comes to the legal system. Because ideally, what we would like to get is verdicts that are right all the time. But truth is a complicated thing, even when you take out the question of perspective. So let me ask you a question. If you pull up to a stop sign, what are you required to do before you go on through the intersection? Come to a complete stop. At what point?
The stop
Supposed to
sign.
go equal front end of your vehicle to the stop sign.
Okay, so you say the stop sign. Anybody else have a different answer?
And if there's a crosswalk there too.
Before you enter the intersection.
Okay, so before you enter the intersection, anybody else have a different answer?
Limit line.
Okay, so this is the police officer. This is the great thing. If you're a police officer and you really, really wanted to stop someone, all you need to do is wait till they come up to a stop sign and then they go. Because you can stop them because the law is completely unclear on what an actual correct stop is. It could be the stop sign. If you pull up with the front of your car, you want a stop sign, that could be legitimate. It could be the line, if there's a line drawn across there, it could be that line, whether that's before or after the stop sign. It could be the actual point of the intersection as defined by the edges of the sidewalk or of the streets themselves. All three of those are legitimate, and all three of those can be used as a definitional thing. So if you really need to stop somebody, all you have to do is wait till they come up to a stop sign. For one thing, they're probably not going to stop all the way anyway, but even if they do, you're going to be able to, you would pull them over and use that argument, at least to make contact with them if you're a police officer, to kind of get a feel for what's going on, based on the fact that they have done the wrong thing, even though they might have been doing the right thing as far as they were concerned. So truth in this situation is that there are three different definitions of what an intersection is and where you have to stop, and they're incompatible with each other. So when you think about our legal system,
Well, what's the thing he said? Limit line.
the limit line is like the white line across there that shows where the beginning of the intersection is.
Well, I was gonna say, up in our neighborhood, they just cruise right on through there.
Oh, right.
They don't stop.
Oh,
They
yeah,
don't even pretend that there's no lines
I know.
there, so I guess they feel like they don't have to stop.
My point is not that most people actually follow stop signs. My point is that even if you're trying to do what you're supposed to do, you're subject to three different definitions that are usually not compatible. Now, occasionally, on a very rare situation, all three of them are the same thing, but it's unusual for that to be the case.
There's one more definition of a stop sign.
Okay?
If you're riding a motorcycle or a bicycle, you're supposed to be at the stop to the point where you have to put your foot down on the ground.
That's true. So what would complete stop means
They
in that
don't do
case?
that either.
No, I'm sure not. Bicyclists never stop at stop signs. But anyway, okay, we're getting a little bit far afield. The point that I'm trying to get at is it has to do with truth, okay? So the truth is that you might have done everything that you thought you were supposed to do in order to stop and follow the law, and yet you still might not have done it because the law doesn't always transact in what's true. They transact in rules that may not always be compatible. When we talk about evidence, we would tend to think, most people tend to think that the best evidence is what? Eyewitnesses, okay? In reality, Mark, is that the best kind of evidence? No, not usually. Now, if a police officer is telling you what he saw, I have a pretty high level of confidence in it, because a police officer has been trained to observe and to note as he sees things happening, and he also is much less likely to be affected by shock or surprise or unexpected situations. Not that unaffected, but less affected. Most of us, when bad things happen, our vision gets real tight and we lose track of most of what's going on around us. We make assumptions about what we think is happening based on what we think should be happening, and we basically can convince ourselves we've seen things we haven't seen. Police officers have training at least to help them with that. It still doesn't make it go away, but it helps. So if a police officer goes in and says, this is what I saw, I have a fairly high level of confidence in it. But eyewitnesses in general are extraordinarily unreliable. Eyewitnesses make mistakes about who they identify, what they say happened, why they think things happened. If you take three people who watch a collision happen out there at the street's corner, assuming that all of them have uninstructed views and they're in different places, and even if they're right next to each other, and you immediately separate them and ask them what they saw, you will not get three consistent answers. If you're lucky, you'll get three answers that mostly overlap on the important stuff. But if you got three consistent answers that were the same for three people, you know they're colluded. It's the only way you're going to get three consistent answers about what they see from people. So the irony is that eyewitness testimony is deeply problematic even when people are trying to be honest. Forget about what happens when people are trying to lie. That's a whole different thing altogether. That was what we looked at last week when we looked at the situation with Jesus when he was on trial, where they can't actually find anybody to lie about him. And so they end up having, or they actually can find people to lie about him, it's just that they can't manage to make it make sense. So they're giving false testimony, their testimony isn't consistent. And then they begin to say, he will, they heard him say, I will destroy this temple made with hands, and in 3 days they will build another made without hands. It's kind of interesting because Jesus has made statements throughout his career as a rabbi that actually would have been sufficient for them to find him guilty of blasphemy, because he has made several claims that either directly or indirectly equaled himself with God. And so it's kind of interesting that they could not find anybody to give a truthful statement that would have allowed them, granted, it wouldn't technically have been about blasphemy because he was God, but in the absence of, since that contradicts their understanding of reality, they would not have been unjustified, or it would not have been unexpected if they had found him guilty of those things, if he had said those things. But either because of the indirect nature of what he said, or whatever it was, they could not find people that were able to make consistent claims against him. And that's generally the truth with eyewitness testimony. It's very difficult to find eyewitnesses who can tell you the exact same thing, or who can recount what happened in detail, especially where those details tend to line up. There tend to be big differences.
The interesting thing about this whole story about this trial of Jesus is that the leaders like Caiaphas and Pontius Pilate, and then also Herod,
yeah.
Felt compelled to do the process in such a way where they would not be guilty of a wrong, when their whole objective was to, well, maybe not Pontius Pilate, but the whole objective was to get this guy killed. Why didn't they just pay somebody to kill him? It seems very weird to me that they have this sort of moral obligation, or maybe just a cultural obligation, to not commit a crime in the case of Jesus, but they did everything possible to do it. Why didn't they just hire it out or do something because that happens all the time anyway. Just take care of the situation. I don't want to deal with it anymore.
Well, anyway, I'm going to let Ken answer. I have a theory on that, but you may have it already.
They had one huge problem with doing it the way Steve suggests. They didn't want to act publicly and preemptively because they were afraid of the people. He was swaying thousands away from their power position, and so to regain that, if they can have him condemned publicly and crucified and killed as a common criminal, that would go a long way to discrediting him, they thought, with his disciples.
Right. The issue isn't, and it doesn't have to be that they kill him personally, publicly. The reality is that whether he dies because, the temple guards got and stabbed him to death, or whether it's because they hired an assassin to poison his food, people are naturally suspicious of that kind of a situation. When you have a messianic type of figure, and obviously he's the Messiah, so he is the ultimate messianic figure, but when you have a messianic type of a figure, and people have bought into him as a Messiah type figure, then anything bad that happens to him, by at least the people who follow him, is going to be presumed to be something nefarious. So, trips and falls down and breaks his neck, eats something that disagrees with him and dies. Those kinds of things that normally when they happen to somebody, you're just like, well, that's a bummer for Jim, but let's move on. But when it's somebody who everybody knows that the people in power don't like, who everybody knows that there's something, that there's that what he's saying is challenging and problematic. If that person dies, even under what appear to be natural circumstances, you're going to have a cult rise up around that. You're going to have a group of people that are going to be questioning what happened and why it happened. So, for example, in our history, we had this period of time in the 1960s where 4 different civil rights presidential type leaders were assassinated in the space of 5 or 6 years. John F. Kennedy, Martin Luther King, Malcolm X, and Robert F. Kennedy, all in a very short period of time. And in every case, it is believed by a large portion of the American public that there was a larger conspiracy that went on either to kill them or to kill all of them. And even though the evidence doesn't necessarily support that, that's what a lot of people believe because, number one, because of the positions that they were taking, number two, because of the fact that all this happened in the kind of the same space of time. But we build into these things this idea that there's a pattern, even if there isn't necessarily. So the high priest can't afford to just kill him extrajudicially. They need to undermine him. They need to discredit him. It's, in a way, it's kind of the problem we have right now. The situation that exists with Donald Trump, which is a weird situation. He has himself said, I'm pretty sure I could go and shoot somebody in the head on Fifth Avenue and the people that vote for me would still vote for me. And he's not wrong. A lot of people who believe in him regardless of what the facts or evidence is. And so in his situation, if he were to die unexpectedly, which presumably would be the situation, if he were to car wreck, if he were to eat something, disagree with him and die, or trip and fall down, or whatever it is, if he were to die, many of the people who believe in him and could not be deterred from believing in him, even if he did shoot somebody, are going to assume that he was killed. And so even if he were, so the only way, in theory at least, to get those people to stop believing in him would be to discredit him in some way, to have him say or do something publicly that would undermine what he's doing, or something like that. And so that's what the high priests need with Jesus. They need a way to discredit him permanently, and so they need the forms of a legitimate proceeding. And because they can't achieve those forms, ultimately it becomes suspect. And it doesn't make things any better that neither Herod nor Pilate will accept what they're doing as being legitimate. Now Pilate ultimately carries it out, but Pilate carries it out from the standpoint of, I don't care, I really don't care. I'm Roman, you guys are a bunch of barbarian savages, and if you want to kill this guy, and it means you won't riot, and I won't have to explain to Rome why you rioted, then that's cool with me. Do what you're going to do. But that delegitimizes what the high priests have done, because the guy who's in charge, the guy who's actually making the decision, is basically saying, you don't really have a good enough reason. I don't care. But ultimately it puts them exactly where they didn't want to be, which is having to do it under the color of authority, but without actually having a legitimate reason for it. So that's kind of the problem that they have in this situation, is they desperately want to be able to show that he's done it. And yet they can't seem to come up with a clear argument.
And that's reinforced by the argument they had with Pilate on the sign.
Right.
The King of the Jews in 3 languages. And they said, but that he said he was the King of the Jews. And Pilate said, what I've written,
I'm done.
Deal with it.
Yeah, I'm done. You don't like it? Too bad. And so, and Herod won't help them either.
No.
Herod basically just takes one look at it and he's like, I'm not messing with this. You go figure this out.
Guess who was his new best buddy?
That's it.
Pilate.
Pilate, yeah.
Yeah.
Because neither of them want to do each other. Yeah, you don't want to deal with it. So ultimately, this is all about creating a false narrative. And this, of course, is the biggest danger of eyewitness testimony, which is that the eyewitnesses have been compromised, and that they're lying about things, and that there's that kind of a problem. And so ultimately, when we talk about the Ten Commandments, we talk about witnesses and being a witness, and I've called this witness for the prosecution because it amuses me to call it that. We see this passage that says, you shall not bear false witness against your neighbor. Now, this is specifically, as I mentioned last week, talking about the criminal proceeding, or the proceeding where guilt is being determined. But it is more broadly applicable to the idea that people are expected to be honest in their dealings. And so in Leviticus it talks about, you shall not steal, nor deal falsely, nor lie to one another. You shall not swear falsely by my name, so as to profane the name of your God. I am the Lord. In other words, you handle the truth correctly, at least insofar as you know what the truth is. And this is where the truth kind of gets to be a sticky thing. If I know I stole something from somebody, I know what the truth is. Nobody else might know the truth, but I know what the truth is, and I'm expected to handle that correctly. If I see someone hurt somebody else, and that's what I've seen, then I'm expected to tell people what I've seen correctly and accurately, not to hide it, not to embellish it, not to try to make sense out of it, but simply to say, this is what I saw. So truth, now that doesn't necessarily mean that what I saw is entirely representative of what happened. If I see the latter half of a fight between two guys where one guy was getting the business end of it and turned it around and ends up defeating the other guy, I may misunderstand what happened. It may look to me like one guy just beat up another guy for no good reason. But what really happened may be more complicated, but my job isn't to try to figure out everything that happened. My job is to figure out, to say, this is what I saw. And so that's what a witness should be doing, is to give an accurate representation of what they saw, insofar as what they know. So we're not supposed to deal falsely, we're not supposed to lie to one another, and we're not supposed to swear falsely by God's name. Now, the Pharisees kind of come up with a creative way around this particular problem by giving weight to different kinds of oaths. It wasn't so much that they were lying about things under oath, that they weren't going that far. What it was is they would say, this, I'm giving you this oath and I'm going to do this thing. And then later on, if they didn't want to do that, then they give a different oath that had a higher value associated with it by what they were swearing by. And that would then mean that they, could get out of the first oath because they gave a second oath with a higher value to it. And that's why Jesus is ultimately saying, let your yes be yes and your no be no. Because if you do it that way, no one can ever really trust what you say, If you write contracts or you sign contracts that say, I'm going to pay X amount of money in exchange for this, and then later on you sign another contract that supersedes that one and you try to say, oh, see, I get to do this one, I don't have to do that one, you go to court on that, good luck with that one. You're going to lose real fast because you signed the later contract, You ignored the provisions and expectations of the first one in favor of doing something different. So we are expected to be honest and to handle the truth as well as we can within the limitations of what we do and don't know. And that's, when Paul talks about a workman not ashamed handling the truth, he's talking about the gospel specifically there. But more broadly, when we handle the truth, as Christians, we should be doing our best to treat it with reverence and to be consistent about how we do it. Okay, so the witness bias problem, and I use the word bias in two senses. Number one, in the sense of someone not having a good perspective on it, or perspective being a factor. And number two, from the standpoint of the fact that witnesses tend to make mistakes about what they've seen, is probably part of the reason why the requirement in Numbers is that when it comes to murder, it says if anyone kills a person, the murderer shall be put to death at the evidence of witnesses, but no person shall be put to death on the testimony of one witness. So we've got to have more than one witness in order for a person to be put to death for murder. So in this situation, what kind of witnesses are we talking about? Direct evidence or circumstantial evidence?
Eyewitness.
Eyewitnesses, so direct evidence in this case. So one of the things that we find that in Jewish law is that there is no, really, at least not for a murder, there's really no circumstantial based cases when it comes to this kind of crime. And to a certain extent that makes sense because you don't necessarily have the kinds of circumstantial evidence available to you. You can't do forensics, you can't do a lot of those kind of analytical kind of things. But it also creates some sort of interesting situations. So think about now what you know with evidence and proof and all that different stuff, and apply that to the story of Solomon and the two mothers who come in front of him with the baby. And they're both saying it's my baby, and they're both saying, that the other one rolled over on her baby and it died in the night, and this is theirs. Solomon has a real problem because according to the Jewish law, he doesn't have any way to make a decision in this situation. There's no evidence that he can use. He's got two witnesses and their testimony is directly opposed to each other, so he has no evidence that he can use to actually reach a conclusion. So what does he do?
Tells him to cut him in half.
Tells him to cut it in half. He basically steps outside of the box to think about a way to find out what's true. Now, notice though, that ultimately, what does he use to conclude who the correct mother is? What's that?
The baby.
He uses the baby in a sense, but what kind of reasoning or thinking is he using to conclude who the mother is?
That the mother will intervene. I rather give that baby up to the other woman. I don't want it to be
Okay,
killed.
so he's using what he expects her response to be. There's a term that we use for this. It's actually a term that's associated with circumstantial evidence. You saw it a little bit earlier. It's called an inference. Inference is when we reach a conclusion based on evidence or based on reasoning that supports a further conclusion that isn't necessarily directly obvious based on the evidence that's been presented. So Solomon infers from the way that from the way both of the mothers react, who the true mother is. And the Bible tells us he got it right, which is a convenient thing about having an inspired prophet to answer it, because in our world, when a judge makes a decision, nobody gets to say, and he got it right, because nobody knows for sure. So it's problematic from that standpoint. But it's interesting, the point that I'm making with this is that even in a system in which direct evidence is the only standard normally, inference is still being used. And we don't know exactly how that was applied more broadly within the Jewish legal framework, because a lot of this stuff, we're talking about thousands of years ago when a lot of these things are happening, and so we don't know exactly how they look. But what's critical in this, however you want to look at it, is the idea that witnesses need to understand that they are under oath, that they are under an expectation of speaking the truth, and that you need to have multiple witnesses in general to establish something. In the New Testament, we have something that says you need more than one witness to go forward with it. What's that?
elders.
Charge against an elder, okay? You need more than one witness. Now, we have expanded our notion of what witness means, but there still is the idea that you need to have more than one person to substantiate a charge against an elder because of the serious nature of that and because of the role that they have. Okay, we need to stop because we are at 10:15 and I don't want to run over today.